Hi, so I'm Becca Williams and I'm one of 2 law fellows at Pembroke College, and this year I'm also coordinating admissions for the law faculty.
And hi, I'm Adam Perry, and I'm one of the law tutors and fellows at Brasenose College, also at Oxford.
So we want to talk to you a little bit about how the interviews work. So you will find that you should have 2 interviews at one college and then almost certainly a 3rd interview at another college. So you might find when you apply that you apply to one college, you're invited to interview at a different college, you're seen as interviewed by a 3rd college, and then you might even be taken for a place at a 4th college altogether. And that's just because we really want to make sure that we spread the applications across Oxford as fairly as possible, so that across the whole of the law faculty, we're taking the absolutely best people that we can on the course. So I'm going to hand over a little bit to Adam to talk to you about what it is that we're looking for in the interview.
Thanks, Becca. So just before the interview, you'll almost certainly be given a bit of text to read over, about 20 to 30 minutes to read it. And that text might be a legal case, or part of a case. It might be a section of a statute, or it might be a part of an article or some other type of legal material. So as I say, about 20 to 30 minutes to read that over, and then you'll be called straight away into the interview room and asked some questions about the material that you've read. And we listen to your answers and ask you follow-up questions, and then we try to evaluate what you said against some criteria. And there's 3 criteria that we use. And so one is about communication. It's just how clearly, how concisely you've articulated your thoughts. The second is about your reasoning ability. So how well have you understood what you've read? How able are you to respond to objections that the interviewers raise to the points that you make? How well are you able to work out the implications of some of the claims that you've made, and so on? So reasoning ability, that's the second point. And the third is about motivation. That's about how keen you are really to study law. And so we assess the answers against those criteria and use that to help make admissions decisions. Becca, is there anything you want to add?
So just in terms of the role that the interview plays in the whole admissions process, it is obviously important, but it is only one of the pieces of information that we look at. So we will also look at things like your GCSE results, if you have any, or your post-16 qualifications, whatever they are. We'll look at those in context. So we won't just look at the raw score. We'll look at exactly, how well you performed against your own background and against the context of your own school. And we'll look at your LNAT tests, both your multiple choice test and your essay. So the interview is important, but it's only one of the factors that we'll look at alongside those other factors. And the other thing that's really important to say is that you don't need to know anything at all before you come to the interview. It's not really an interview that you can revise for like it might be in some other subjects. So really, we're just trying to test your innate ability and how well you can do with materials that you've never seen before, that you just have to respond to on the spot. So for that reason, when you see us do the interview in a bit, the person that we're going to be interviewing is somebody who is herself not a law student. So she is an Oxford University student, but she's not studying law. So that means she's in the same sort of position that you would be in that she doesn't know any law before we start talking to her. And it's all about how she reasons through things on the spot.
Well, hello, Grace. I'm Adam Perry, and I'm a law tutor and fellow at Brasenose College at Oxford.
And I'm Becca Williams, and I'm one of the 2 law tutors at Pembroke College.
Thanks a lot for joining us today. So I wanted to start things off by asking you just a few questions based on your personal statement and a little bit more generally, and then we'll come to this passage that you've been asked to read. Does that sound all right?
Yeah, that's absolutely fine.
Great. So I see from your personal statement that you like to read, and so I was hoping you could tell us about a book that you've read recently that you enjoyed.
Yeah, absolutely. So one of the books I've read recently is actually a music book. It's Susan McClary's Feminine Endings. It's a very interesting book. It's basically Susan McClary essentially attempts to put a gendered view on Western classical music. I think it's particularly fascinating because Western classical music's just been gendered masculine throughout history. And it's great to put a view of gender studies, a more 21st century point of view on Western classical music that we may not necessarily consider in today's society.
That sounds really interesting. Could you tell me, how is it that view that different point of view is argued for?
Yeah, so one of the ways she argues about the gender roles is actually through sonata form. So in sonata form, you've got a primary theme, the first theme, and a secondary theme. And she argues that the primary theme is gendered masculine. It's more assertive, it's more like a march kind of theme, whereas the secondary theme is more feminine, it's more lyrical, it's more dolce. And basically she tries to understand how these two themes have kind of been created in that way without actually the composer knowing that he's doing that. And she links it back to culture, back maybe when Beethoven was writing. Yeah, so she tries to unpack that and then basically place it in a 21st century lens. Yeah, it's really fantastic.
Oh, that sounds very interesting. I'm sure we could talk about that a lot more. But
Yeah, of course.
so in addition to music, you're interested in law, and so I wondered if you could tell us, what attracts you to law. Why do you want to study law?
Yeah, so one of the main reasons I would like to study law is due to the fact that in law you're reading, you're analysing, you're constantly putting a critical lens on anything that is with the law. It's to do with everyday life. It's present absolutely everywhere. So it would be fascinating to do a degree in which you're testing your intellectual capability in addition to actually doing something that is very contemporary, very current, and can follow you throughout your whole life.
Terrific. Well, I think that is the hope. So I'm glad that that's how you feel. So I'm going to hand things over at this point to Becca, who's going to ask you the first question, and then I'll come back in a little bit later. Becca?
Great, thanks, Adam. So, Grace, we sent you this passage before the interview. Have you had a chance to have a look at the passage?
Yes, I have.
And do you feel okay talking to us a little bit about it?
Yeah, I do. Yeah, so I can take it away.
Yeah, exactly. So tell us what the passage is about and what's the point that they're making in that passage.
So I've basically summarised each paragraph briefly, tried to put it into more regular words. So the first paragraph, I thought that it was talking about how a duty of care should be a relationship of proximity or neighbourhood between the two parties. In the second paragraph, part A, before we get to the quote, the issue here is that if you're developing a relationship of proximity or neighbourhood, they're rather intangible concepts. So it's very, very difficult to measure to what degree one has that proximity or fairness. So it's very difficult to measure it in court. And then the quote, Brennan J. So believes we should we have developed categories of negligence, and perhaps we could apply those categories of negligence to categories of proximity, fairness, neighbourhood. And then the third paragraph, I thought that it was Sorry, let me just gather my thoughts.
Yeah, please do take your time.
Yeah, so the third paragraph was about chattel, which I did have a question about precisely what chattel meant, but basically it was discussing that one has a duty of care to avoid injury to a person or property, but there's also this opposing side where one has a duty of care to avoid causing others purely economic loss. And before I ask what chattel means, the final paragraph says that there's no legal recognition of any wrong done whose rights are around profits. So the recognition is about injury to the person or property of others, whereas there's no recognition if it's just for economic profit. Yes, so I had two questions about this paragraph. So the first one was what chattel is defined as.
Yeah, you're absolutely right. It's a really, really old-fashioned word, which we do still use sometimes, because you'll find out that law sometimes does use quite old-fashioned words for things, and it just means a piece of physical property. So not a sort of piece of what we call real property like a house or something like that, but just a kind of piece of movable property that's inside that. So not a person but a thing, basically, is what you can understand a chattel to be in that sort of context. Does that make sense?
Yes, yeah, that makes sense. So the profit can, the issue with duty of care to avoid causing economic issues, can that be used in like business situations as well as personal?
Yeah, exactly, that's right. So if I just take you excuse me, if I just take you back to the first paragraph, and
yeah,
if you were sort of writing rules for somebody, and somebody was saying, right, I need to know when there's going to be one of these duties of care, what would you say in that first paragraph are kind of the ingredients of the duty of care that you're told that you need to look for there?
I would say so. The ingredients are to do with the proximity and neighbourhood. So perhaps one might want to like almost define what proximity and neighbourhood are. So when I first read this, I was considering duty of care in terms of a family law situation. So if we were to take, say, maybe two parents that have split up, and maybe it's a question of duty of care for the child, proximity could be defined as where each parent's living, how accessible is that to the child, and neighbourhood, perhaps how available is each parent for the duty of care.
So you're right, we use duty of care in lots of different contexts in law, and that sort of family law context is very much one that we might use it in. In this paragraph, what they're talking about at the beginning and in that last section that we were just talking about in relation to the chattel, they're talking about situations in which one person causes another person damage. So that's the very particular context in which they're using this idea of duty of care here. So you're absolutely right that they say that you need a relationship which has something like proximity or neighbourhood in it. And then there are two other things at the beginning. They say that the damage has to be what? And what's the other thing at the end of that paragraph that they also say that the law has to think about in imposing that duty of care?
So at the end, it should be just the court should consider the situation just and reasonable.
Yeah.
And it should consider the scope of the duty of care. And at the beginning, the court should consider the foreseeability of damage, which I suppose is that I assume is that considering the level of damage, the perhaps considering how this has any knock-on effect in the future.
Good, exactly. No, that's exactly right. That's really good. So let's see if we can sort of test out what we've learned now. So we've got our ingredients and we know what's going to go into making a duty of care. So I want you to imagine that I'm driving my car down the road. Do you think I have a duty of care to a cyclist on the road. So if I have an accident and I hit that cyclist, would the court say, yes, you know, you had a duty of care and so you're liable for the damage to that cyclist? Do you think that's what the court would say?
Yes, I think the court would say that, because if you consider foreseeability, if you were to hit that cyclist, for you it may just be maybe a bit of whiplash, whereas for the cyclist it could be completely life-changing. So if you consider how those effects could happen in the future, they may not be able to walk, they may have severe brain damage from the situation. And then the duty of care for proximity and neighbourhood. I suppose I may be thinking too literally, but maybe proximity, you are close to the cyclist. Yeah. You are neighbourhood, also proximity related. And then duty of a given scope. I suppose the scope is that while you are within proximity of the cyclist, you have a duty of care not to hit that cyclist, but the scope is that once you pass that cyclist, you have no duty of care for the rest of their life.
Good. Okay. Now imagine that I do have that accident and I do hit the cyclist, but there's also somebody standing on the street corner and they see that accident happen, and because they're really worried about what's going to happen to the cyclist and they're very traumatized by the whole thing, they then develop PTSD, post-traumatic stress disorder, because they've been so emotionally upset by watching this accident. Do you think in those circumstances I would have a duty of care to that person? Do you think I could be held liable for the damage, the sort of psychological damage to them?
No, because I suppose the pedestrian is not necessarily counted as part of the like the road situation, the highway code. Neither is psychological trauma. Say if you hit the cyclist and the cyclist had a knock-on effect and hit the pedestrian, maybe then you would have some kind of duty of care, because it would come under foreseeability maybe and proximity. Whereas the PTSD, it's not necessarily a direct result of your action towards the cyclist.
Good. So if you were going to explain which of our kind of ingredients, if you like, of a duty of care is weak there in relation to the pedestrian, which is the one that you think is weak or it's missing, so that's why we haven't got the duty of care there?
Perhaps neighbourhood. It's not a direct neighbour. I would say the cyclist is a direct neighbour.
Good.
Yes.
Yeah. Good. Okay. Now, a completely different scenario. So I want you to imagine that I'm asleep in my house and downstairs there's a broken floorboard and I know it's broken and I keep thinking, oh, I really must fix that floorboard, but I haven't yet. And while I'm asleep in the night, a burglar comes into the house to come and steal my TV and my computers and things, and they fall into the hole in the broken floorboard and they injure themselves. Do you think I've got a duty of care to that burglar?
No, because the burglar is not supposed to be in your house. So I would say that if you were, I suppose you could kind of consider these two legal issues like hanging in the balance. Which one is, I suppose, more of a serious offence? The burglar is directly breaking the law. He's breaking and entering. He's not supposed to be in there. So I suppose by breaking that law, you kind of maybe negate the duty of care that you would have. Whereas if it was maybe a guest you had invited, a family member, and they were injured due to the like the hole in the floorboard, then perhaps you would have a duty of care because you had invited them into your home, you in proximity with them. So then the duty of care would fall to you.
Good. So you're absolutely right to draw that distinction between a guest and the burglar. What you said is, so are you saying that you think I have got a duty of care, but it's just that the law will say, well, you might have a duty of care, but we're not going to pay attention to that because they're a burglar? Or do you think I might actually not even have the duty of care in the first place? Might a bit of the duty of care even be missing?
I would say the duty of care would be missing because it's your personal property, it's your house, and the burglar is not I think the clear distinction is that the burglar is not a guest. The burglar is not supposed to be there.
Right. And so because they're not supposed to be there, from my perspective, what's missing? So if I invite a guest, then that thing is present. But if it's somebody who comes into my house unannounced and unwanted, what's missing from my point of view?
Neighbourhood, perhaps.
Good. Okay. So I'm going to hand you over now to Adam to ask you some different questions about some other things.
Thanks a lot. So Grace, we're going to change gears here a bit, so you can put the passage that you read out of your mind for now. Instead, I want to ask you about some other scenarios. Okay.
Yes.
Okay. So this first scenario is about a law that says that anyone who is riding a motorcycle needs to wear a helmet. Okay. Mm. And it's a criminal offense not to do this, not to wear a helmet while riding a motorcycle. But there's a Sikh man who can't physically wear a helmet without removing his turban, which he doesn't want to do for religious reasons. And so here's the question then. Should the law make an exception for this kind of case?
No. I don't think the law should make an exception for this kind of case, primarily because with a motorcycle, say if that motorcycle was to be involved in an accident with a car, in fact, or a pedestrian, it's not the responsibility of the pedestrian necessarily to move out of the way because that cyclist is maybe not wearing a helmet. I suppose you could almost link it back to duty of care, that the cyclist should be wearing, the motorcyclist should be wearing a helmet, due to the fact that if they were to be in an accident, they would, primarily with a car, they would almost be making the driver of the car liable if they were to have a head injury.
Okay, can I just stop you for one moment, Grace? So let's just put that passage and what you read from it sort of out of our minds for now. Okay, so we'll treat it as irrelevant here. So all that talk about duty of care and negligence, let's put that aside for the moment. And so we're focusing here on just this single law that makes it a criminal offense. It doesn't talk about negligence or liability. Instead, it makes it a criminal offense, and maybe that's punishable by a fine or some other kind of sanction, some other kind of bad consequence. Not to wear a helmet while riding a motorcycle. And so with that in mind, just this single law in our focus, what would you say then? Would you stick with your answer, or would you revise your answer?
I would question the law of maybe the religious law of wearing a turban, and weigh that up against the law of the jurisdiction that the motorcyclist is in.
Okay. So I wonder if you could tell me, should the law, do you think the law should ever make exceptions to accommodate people's religious beliefs, where those beliefs might require them to act in a way that the law tells people not to act? Should the law ever make exceptions for people's religious beliefs, do you think?
I would say it depends on the law. It depends on whether the law is preventing others from getting hurt, other people's rights, human rights. If the law covers any of those issues, I think there should be no exception in that jurisdiction. However, if say you were to have a law saying young girls cannot go to school wearing a hijab, let's say, like that's the law in the jurisdiction. Wearing a hijab is not harming anyone. It's having no direct impact on anyone else aside from the person wearing the hijab. I think maybe then you would reconsider whether you would follow the law or not.
That's a really good example. So I wonder if you could tell me whether there's a difference between that example that you just gave and the situation where the Sikh man wants to ride a motorcycle without removing his turban. So by doing that, is the motorcyclist gonna interfere with the rights of others or harm others?
I suppose maybe not directly, but if you consider his own rights to stay safe, maybe not take up like time from ambulances, etc. You could consider the knock-on effect of like an ambulance rushing to pick him up, the time taking up like a hospital bed, just because he didn't wear a helmet. So you could consider that maybe taking up that hospital bed because you didn't wear a helmet and you are now maybe in a vegetative state, perhaps that is having a knock-on effect on someone who may have needed that hospital bed, and that law was already there.
Okay, that's an interesting point. So imagine for me then that we didn't have the National Health Service and that we weren't going to assist this man were he to have an accident and be injured. Would that change your answer?
No, because I think there would still be the issue of having hospital beds available. So like without the NHS, you'd still need the beds there, regardless of like whether you're going to pay or not. I think the man would still be taking up a bed, and that bed may be needed by someone who would pay.
Okay, one last variation then. So let's just assume that if the man gets into an accident, he's going to die. Okay, so he's not going to be injured, so he's not going to require any medical care. So he's either going to ride and he's not going to have any accidents, and all is going to go well, or he's going to have an accident and he's going to die, so he's not going to need a hospital bed. Does that change anything? So he's not going to require any medical care
because he's going to die.
Yeah. So we're not gonna spend any money on him, and it's not going to cost the government anything. If he gets into an accident, he's going to suffer. It's going to be harm to him, but it's not going to harm anybody else. Does that change anything?
No, because even though he's going to die, if one was to maybe, I mean, at the end of the day, if he's dead, you can't exactly file a lawsuit against him. However, if one was to perhaps ignore the fact that he wasn't wearing a helmet, it could probably set a precedent for other motorcyclists who think that it would be okay to do that, and that the law would not question the issue.
Okay, that's fair enough, Grace. It's probably a pretty silly scenario I was describing anyway. So I think Becca is going to ask our last question. Becca.
Okay, cool. So let's imagine that you are in charge of a country, so you can do whatever you want. You don't need to worry about what the law actually is. And somebody points out to you that people are quite often killed in accidents at traffic lights because somebody runs a red light. So the proposal is that we should impose the death penalty for anybody who runs a red light and drives through when the light says stop, because that way it'll stop the accidents and it'll stop people from being killed. Do you think that's a law that your country should enact?
No, because although, sorry, firstly, I would actually question in what sense, how would you define running a red light? Would you consider whether this person had done it on purpose or by accident? Because if someone had run a red light by accident, but that law did not cover that situation, then the death penalty would be imposed on someone who had just made a mistake.
Okay, so then let's refine our law and say, okay, we'll only impose it for intentional running of red lights. Should we say that? Should we have a law that says death penalty if you intentionally run a red light?
No, because I suppose you could kind of suggest that by having such a law, if I would question also running a red light, and would you have to injure someone, kill someone, or would it just be the death penalty for just the act of running
the red light in and of itself, even if no other bad consequences happened?
No, I think I wouldn't have that law, because I think it would almost create quite a slippery slope of these kind of laws, like running red lights. Then you might have one for jaywalking. What if that's the death penalty? I think it would create, maybe, to speak of politics and like social, like culture, I would say it would probably create a sense of fear among cultures. So perhaps it would maybe reduce the number of people driving. People would maybe be afraid to go out, travel. I think it would be detrimental maybe to society and their maybe faith in the ruler, to the point that it would be so detrimental that it would maybe outweigh the maybe the reduction in deaths.
Good. Those are all really, really good points. Thank you, Grace. So I think that gets us to the end of our interview and our asking you questions. Are there any questions that you want to ask us at all? And you absolutely don't have to. And if you do ask us any questions, they're absolutely not part of the interview. They're just, if you want to find out any information about anything, please do feel free to ask. So is there anything that you'd like us to talk to you about?
Yeah. So what is the examination structure at Oxford for law?
So after 2 terms, you'd come to Oxford in the October, and for 2 terms you would study 3 subjects, which is criminal law, constitutional law and Roman law, and then you'd have exams in those subjects at Easter of your first year. And then when you come back after Easter for the summer term of that year, you start learning subjects, which ultimately you'll be examined on at the end of your final year. So if you do the 4-year course, that's after 4 years. And if it's the 3-year course, you do it at the end of 3 years. And you do those exams right at the end of the course for your finals at the end of your final year in the course. At that point, most of those exams are exams, but you will have done some things, like you'll have done a jurisprudence dissertation after the summer in your second year, which counts towards your final marks, and some of the papers that you might want to do as your option subjects in your final year, some of those are assessed by extended essay rather than by exam, but you get your final marks for your whole degree awarded at the end of your final year.
Fantastic, thank you.
Great. Well, thank you so much for joining us. It's been really nice to talk to you for a little bit.
Thank you, Grace.
Thank you.
So the interview is done now, and just taking a moment to think about how it went. I thought Grace did really well overall, and just in response to those introductory questions, which aren't part of the formal interview or don't make up part of our assessment, but I thought Grace was very good at explaining what the book that she was reading was about and summarizing the sort of key argument there. And she also seemed fairly enthusiastic about studying law, which is great. But again, that's not part of the formal assessment. I also asked about this scenario about the motorcycle driver, but maybe I can come back to that. Becca, do you want to say something about the first question?
Yeah, and I think you're right. It's nice. It's always nice when you see somebody who's kind of genuinely enthusiastic about stuff, and maybe they've read something that's beyond kind of what they have to study, but they've kind of gone beyond that, and it's really nice to see that. And I think it was great to get that sort of enthusiasm from her. So in terms of the passage, obviously what we're looking for there is somebody to understand the passage, to be able to read it and figure out what's important about it. And that process of sort of deriving what the ingredients are. So you might have lots of words on the page, but actually what you want to do is condense it down into, well, basically you need a list of 4 things or something like that. And I thought she was good at doing that. It was good that she could sort of distill those ingredients for the duty of care out of it. So that was really good. I was really pleased that she asked about chattel as well, because there is often some terminology, and we know that's something that candidates might struggle with sometimes, particularly maybe if they're non-native English speakers to begin with. So it's always good to ask for clarification. So I'm really glad that she did that. And then I thought she did really well applying it to the different scenarios as well. I think that was good. She could see the difference in proximity between the cyclist on the road and the pedestrian who gets PTSD. So she got that one really well. With the burglar, there was some really interesting discussion there about whether it was that the duty of care was actually created but then just set to one side because that person was a burglar and so had lost the rights that they had otherwise accrued, or was it that maybe they didn't get those rights in the first place? Maybe it was that the duty of care didn't accrue in the first place, and that was a really interesting distinction. And then obviously sort of looking at things like how foreseeable the burglar was. That would be something that we would be looking at there. If you invite a guest to your house, obviously you've got that foreseeability, but if it's somebody who arrives unannounced and unwanted, then that foreseeability is missing. But I think overall she did really well on the passage, and she had that sort of ability to do the close reading and then apply what she'd read in that context to the scenario. And obviously that didn't require her to have any outside knowledge. It just required her to use what she'd learned on the spot, and I think she did really well with that.
Yeah, so on the second question, which was about the man wearing a turban for religious reasons, who didn't want to remove it, to wear a motorcycle helmet, even though that was legally required. I thought there were a couple of things that went quite well. So one was that Grace was able to draw some comparisons with other scenarios, and so the example she gave was religious dress in a school context, and so I thought that was that was insightful. The second was that she initially assumed that the material from the first question about negligence and a duty of care was relevant here, and that's how she started to think about the scenario. But when I explained that she should put that out of her mind, Grace was able to do that, which was also good. What maybe didn't go quite as well is that some of the later questions I asked her about, imagining a different health service, or, imagining different consequences for the, if there's an accident, sort of scenarios I described as being silly because they were so implausible. Those were meant to get at, to try to assume that there was no harm to others from this decision not to wear a helmet. And I think that that maybe that's not something that Grace saw clearly in the end. Now, that part of the problem there might have been that the questions were a little bit unclearly worded. And so I think if Grace was confused there, that might have been an opportunity to ask questions, and that's something that candidates should feel very free to do. If the question is poorly worded, then it's hard to do, but it's important to do, to sort of just ask, well, could you explain that to me in different words? But yeah, overall, I thought Grace did well there.
Yeah, no, definitely, that's right. I mean, we're a long way from perfect, however long we've been doing interviews for, so it's always good for people to ask for clarification. I think that's right. And then on the last question about the death penalty and running the red light, I thought she did really well on that. So in our terminology, we talk about things like the proportionality, and we'd say, oh, that's a very disproportionate sentence. And obviously she didn't know that word, but she absolutely got that concept. So she was using, the way she explained it, it was obvious that she understood the sort of reasoning behind that concept, even if she wasn't using that exact word. And I think that was really good. And then she also talked about the sort of wider implications that a rule like that might have. And that's very much something that we look for in those sorts of questions is, you might set out to create a rule with a particular intent, but it might have unforeseen or unintended consequences. And can you see what those unintended consequences are? Can you see the incentives that it might create that you don't want for society? And I thought she was really, really good on that. Again, she didn't use the words chilling effect, but that was very much what she was talking about. She was saying, oh, well, this might make people less, more reluctant to drive in the first place, and that would be something that we don't want them to do. So I think she was really good on that, and I think say she wasn't using the terminology we would use, but she was absolutely nailing the concepts underneath it, and sort of understanding the unforeseen and unwanted implications of that rule. And I think that's exactly what a question like that is trying to get a candidate to do, and I thought she did it really well.
Yeah, I agree, and just more generally, she stayed sort of calm under questioning, which is also a good thing.